thank you all for joining us. I'm Rodger Citron, and I'm a professor of law and the Associate Dean for Research and Scholarship at the Touro College Jacob D. Fuchsberg Law Center. Today's event, as you'll see, has many participants, and we're here to honor the life and legacy of Justice Ruth Bader Ginsburg, who recently died. And the format of today's program is that after I do a very quick biographical sketch of Justice Ginsburg, you'll hear from my co-panelists, who are all either current or former members of the Touro Law faculty. Before we start with the program, the thank yous, and there are many. Thank you to Dean Elena Langen, the Touro Law Center's dean, who came up with this idea for us to do this program and enabled it to occur. Thank you at Touro Law to our Information Technology and Development Office. Both offices have done a marvelous job in promoting the event, getting the event to the position it is now where it can occur. And of course, thanks to all of you for joining us today. Justice Ruth Bader Ginsburg lived in some ways an ordinary life, and yet she did so much that was extraordinary. She was born in 1933 in Brooklyn. She enrolled at Cornell at the age of 17 on a full scholarship. There she met Martin, or as he was known, Marty Ginsburg. Together they went to Harvard Law School after graduation. And then when Marty moved to New York City after graduating from law school, she did her last year at Columbia Law School. And so there's much about that story that is both ordinary and extraordinary, right? At the time, a woman in the 1950s following her spouse. After graduating from law school, she clerked for a district court judge, Professor Gerald Gunther, a very well-known constitutional law professor, helped her arrange that clerkship. She graduated at the top of her class. Here too was an ordinary part of the story, right? That because of gender norms at the time, it was not easy for her to get a job. The rest of the story is fairly well known. Before I get to that, here's my favorite biographical fact that I learned about Justice Ginsburg. After she was done clerking in the United States District Court in the Southern District of New York, she learned Swedish so that she could work with another professor from Sweden who was a scholar of Swedish civil procedure, and together they co-authored a book on international procedure. From there, she taught at Rutgers, then at Columbia Law School, at the same time that she was a very accomplished professor. As you'll hear, she began litigating cases, constitutional law cases in the courts, including the Supreme Court. In 1980, she was appointed to the United States Court of Appeals for the District of Columbia Circuit, where she served for about 13 years until President Clinton appointed her to the Supreme Court. From there, we then have, as she was known and celebrated, the notorious RBG. I will now call on, as our first speaker for the program, the Dean Emeritus and Professor of Law at Touro Law Center, Howard Glickstein. Dean Glickstein served as the dean. He held that position from 1986 to 2004. And while he was dean, Justice Ginsburg was a guest at Touro Law. Dean Glickstein.
Thank you, Rodger. Good afternoon, everybody. In 1974, while I was teaching at Notre Dame Law School, I received a letter that was signed by 32 law professors, including Ruth Bader Ginsburg. And in the letter, she announced the formation of the Society of American Law Teachers and invited people to join. I did join, and Justice Ginsburg was very active in SALT, and later on in the 70s, SALT honored her with its highest award. In 2014, on the 40th anniversary of SALT, Justice Ginsburg sent us a letter in which she said, 40 years ago, my 11th year as a law teacher, I was among the 32 colleagues who joined hands to compose SALT's initial board of governors. It was our aim to found an organization concerned with vital issues of our era and to convey to our students appreciation of the important role lawyers could play in helping to repair tears in our society, something that needs to be done today. And she went on to say, the legal profession has had among its members many brave men and women devoted to and at work for the public good, people who are the best of lawyers, the most dedicated and least selfish. She went on to say, I lift my glass to the Society of American Law Teachers in celebration of its 40th anniversary and express the hope that there will be encores galore in the years to come. SALT and Truro have been closely affiliated over the years. I served as president for a term, and two of our faculty members, Eileen Kaufman, who you'll meet in a little while, and Deborah Post at different times served as co-president. As Rodger said, Justice Ginsburg visited the law school in 1997 as our distinguished jurist in residence. What attracted her, what helped us get her to come to the law school was in part Justice Scalia, who had been with us a few years before, told her what a good time he had while he was here. We also had the good fortune of having Jeff Morris, who you'll hear from soon, who had worked at the Supreme Court, and induced her to come. And finally, we offered her tickets to visit the New York City Opera while she was in town at Lincoln Center. And although it was not the Metropolitan Opera, she did accept the invitation. While Justice Ginsburg was at the law school, she spoke one evening, delivered quite a long lecture, and then was very gracious to answer questions for about a half hour. While she was at the law school, walking down the hall with her one day, I told her there was some press to meet with her. And she looked very angry, and which was unusual, and said to me, I thought I had told you I didn't want to meet with any press. And I said, well, these are reporters from the Kitty page of Newsday. They're all high school students, and they're anxious to talk to you. She said, oh, that's different. And she had a very pleasant meeting with them. On another occasion, we had some students visiting Truro from Bar-Ilan Law School in Israel. And those students and some of our students met with Justice Ginsburg in the chambers. And at first, the meeting was very stiff and awkward, and nothing much of a great significance was being said until one of the students pointed to some pictures on Justice Ginsburg's desk and said, who are they? And they were her grandchildren. And she got very animated and excited and talked to them about her grandchildren. While Justice Ginsburg was at the law school, we had a meeting in the auditorium with students, and one of the students asked her, Justice Ginsburg, did you ever meet President Clinton before the day he appointed you to the Supreme Court? And she said, well, as a matter of fact, only once when he interviewed me for the position. But a few years ago, Marty, her husband, and I were in Little Rock on a Friday night, and we noticed that Governor Clinton was speaking at a program, and we went to hear him. And I said to Marty afterwards, wasn't this good fortune that we were able to hear Governor Clinton while we were here? And Marty, who was in the audience, yelled out, should I tell the students what I said after you said that to me? And she said, go right ahead. And he said, well, after Justice Ginsburg told me how fortunate we were to hear Governor Clinton on a Friday night, I said to her, well, what else is it to do in Little Rock on a Friday night? Justice Ginsburg was a very gracious person, and she reminded us that in her office, she had a poster with a quote from the Bible, justice, justice, thou shalt pursue. It's a quote that was it's also at the law school, and it was in the dean's office. I'm not sure it's still there, but it was in the dean's office. And Justice Ginsburg certainly has adhered to that biblical message, as has the law school. So we were very fortunate to have a close relationship with Justice Ginsburg. Thank you, Rodger.
Thank you, Howard. Before I turn to our next speaker, to let everyone know, in the webinar format, there is the opportunity. I see that we have a substantial number of attendees, which is wonderful. There will be an opportunity for a question and answer period after we've all spoken. And the way to do that is that you'll see that you can ask, if you're on Zoom or wherever, there's a Q&A button. Feel free to ask a written question, and we'll try to get to it after the presentations. So our next speaker is Professor Tiffany Graham. She's an associate professor at Touro Law School, and she teaches, among other things, constitutional law. Professor Graham.
Thank you. So I'm really excited to be here today to have this conversation with everyone, because Justice Ginsburg is someone who I always admired, not just as a person, but also as a justice. And in thinking about the work that she did in her life, I'm going to talk to you a little bit about her litigation strategy in the 1970s that was really key to helping create the framework that we use today when we are trying to evaluate the constitutionality of laws that discriminate on the basis of sex. So, you heard a little bit about her life and some of the challenges that she faced over the course of time, especially in following her husband. But she had trouble getting employment despite how brilliant she was, but she ended up finding wonderful opportunities in a variety of places. One of those places was in the ACLU. She wrote a brief for the ACLU in a really famous gender discrimination case called Reed versus Reed that impressed folks at the ACLU, and she ended up founding something called the ACLU Women's Project in 1972 after she had written that brief. And the whole point of that project was to really pay focused attention to eliminating the structural discrimination, the structural barriers that women in particular had been facing throughout American life. So she founded this project in 1972. She's there until 1980 when she is appointed to the bench. And during her time at the ACLU, she either served as counsel in a number of Supreme Court cases, or she filed amicus briefs so that the ACLU's voice would be represented in those different cases. The strategy that she used, though, when she was filing these cases on behalf of trying to eliminate sex-based discrimination was very reminiscent of a choice that Thurgood Marshall made when he was litigating with the NAACP Legal Defense Fund in the years preceding the decision in Brown versus Board of Education. As many of you will know, the NAACP did not engage in a frontal attack on segregation in public schools from the very beginning. Instead, what they did was they created a series of precedents that would help persuade the court to eventually render the decision that they did in Brown. And what they did was they focused in on something that was familiar to the justices: law schools. They filed a number of lawsuits that highlighted to the justices that there was all this race-based discrimination that was happening in law schools that was particularly egregious, and that the states, when forced to come up with a solution to the problems, would oftentimes come up with solutions that were inconsistent with what it meant to be in law school. And because they had this ability to personally key in, they were able to come up with the decisions that ended up helping to eliminate race-based discrimination in schools altogether. Similarly, with Justice Ginsburg, when she began her litigation at the ACLU with the Women's Rights Project, she did something really smart. She focused on men. she filed cases where men were actually the victims of discrimination. By way of example, you had a number of cases where men were being harmed in the benefits regime. You would have, for instance, in one case, there was a statute that granted military housing benefits to the wives of enlisted male soldiers, but the husbands of enlisted women could not get the same benefit unless they could prove that they were actually dependent on their wives. You had another case where Social Security benefits were only given to excuse me, they were only given to widows instead of widowers. You had yet another case where similarly, these death benefits were only given to the widowers if they could prove that they had been dependent on their wives. So she files these cases and she goes to the Supreme Court and points out that it was important for them to try to address these issues and to develop a framework for addressing sex-based discrimination, not just because of the harm that was being done to women, but to the harm that was being done to men as well, that this sex-based discrimination was something that was problematic across the board. And, at the time that she was filing these cases, something really important was happening in the country at the time. We were debating over whether or not we were going to pass the Equal Rights Amendment. And so, while all of that is happening in the backdrop, and while she's trying to persuade the Supreme Court to give her wins on these cases that she's filing on behalf of men, she ran into a barrier that had to do with the way that legal cases are often viewed at the Supreme Court. More often than not, when you file a claim before the Supreme Court takes it seriously, of course, but they don't look super closely at what's happening underneath the surface, unless you're looking at a law that discriminates on the basis of a characteristic that is historically really problematic, like race. Well, she had to work really hard to convince them to do the same thing in the context of gender, in part because the ERA was out there waiting in the wings, and the court didn't want to just make up a rule that would give them the authority to look closely at these sex-based classifications. Instead, they wanted to wait for the country to tell them they had permission to do so. Well, of course, as we know, that didn't happen. And so eventually, one of the cases that she filed, she persuaded them to, in fact, come up with this new standard that was going to result in treating sex-based classifications more seriously than typically had been done in the past. And this was crucial. It was crucial in terms of looking at the development of equal protection jurisprudence with respect to sex-based discrimination, because if she had not been able to convince the Supreme Court to put that way of thinking in place, then she might have been less successful. Future litigators may have been less successful when they went to the Supreme Court and filed their own cases dealing with sex discrimination. So really, in short, and I'll wrap up here, what I would say about her is, apart from being just a brilliant legal mind, she was also a very smart, very careful legal strategist. And the care that she took in putting these doctrinal building blocks together it was so important for her to do it the way that she did, because now we have an entire framework which allows us to actually take very seriously the claims that people make when they walk into court and say, I have been discriminated against on the basis of sex.
Thank you, Tiffany. And our next speaker is Eileen Kaufman. She is a professor emerita from Touro Law School, or at the law school. While she was here as a full professor, she served as the academic dean and won many awards for her teaching. And she taught, among other things, constitutional law. So, Professor Kaufman.
Thank you, Roger. When RBG visited Touro, she was asked which case was the most satisfying to her, and her answer was the BMI case. So I'd like to pick up where Professor Graham left off and talk a little bit about that case and two others that I think best illustrate the role that she played in truly changing the law's response to claims of gender discrimination. So 3 years after she joined the court, she wrote the majority opinion in the VMI case in United States against Virginia, which challenged the exclusion of women from VMI, a publicly funded and highly prestigious institution. Now, the program at that school was clearly not for everyone. Students slept in barracks. They were subjected to physical duress, to mental stress, to a complete absence of privacy. But Justice Ginsburg said the issue wasn't whether women or men should be required to attend VMI. The issue really was whether Virginia could constitutionally deny to women the unique opportunities that VMI offered to those women who had the desire and the capacity to enroll there. And the state defended its complete exclusion of women from VMI by saying if we admitted women, it would destroy the school. And Justice Ginsburg said that's precisely the argument that has been used to keep women out of all the professions, out of law, out of medicine, out of the police forces, out of the military academies. So she strongly rejected that argument and instead held that the exclusion of women from VMI constituted unconstitutional discrimination in violation of the Equal Protection Clause. So given President Trump's recent nomination of Judge Amy Coney Barrett, who clerked for Justice Scalia and who says that he is her mentor, I think it's worth noting that the sole dissent in the VMI case was Justice Scalia. And I think that's important because maybe that's a harbinger of what's to come should Judge Barrett be confirmed. Scalia would have upheld the state's exclusion of women from VMI. Why? Because in his opinion, challenges like that should simply not be heard by the courts. They should be left to the political process. And what does that mean? It means that when the majority wants to change something, it will. So let me move on to the second case I want to briefly mention, and that's the Lilly Ledbetter case. Some of you may remember the name Lilly Ledbetter. She was an area manager for Goodyear, and she was paid far less than every single male counterpart that worked for that company. Despite that, and despite the fact that those facts really weren't in dispute, she lost her case 5-4 in the Supreme Court. Why? Because she failed to file her Title VII claim within 180 days after receiving her first paycheck. Well, Justice Ginsburg wrote a blistering dissent in that case, and she chided the majority for being absolutely clueless about the invidious way that discrimination against women operates. She pointed out the obvious, that discrimination is reflected in every paycheck that Lilly Ledbetter received, not just her very first one. How could she have known when she received her very first paycheck that she was being paid so much less than the men who were doing the same job? And importantly, Justice Ginsburg ended her dissent by explicitly calling on Congress to correct the error that the majority had created. And they did just that with President Obama signing the Lilly Ledbetter law in 2010. So even when writing in dissent, Justice Ginsburg managed to move the law towards gender equality. And Lilly Ledbetter, when she heard of Justice Ginsburg's death, said, "She changed my life and she changed the country." So let me end by mentioning the case that Justice Ginsburg told us about when she was at Turo in 1997. She was asked, what was the most satisfying case of her career? So she said on the court, it was the VMI case, but actually the case that meant the very most to her was a case that she litigated. And she told the story about Stephen Weisenfeld, whose young and healthy pregnant wife went to the hospital and died of an embolism while giving birth to their son, Jason. And Stephen vowed to take care of his newborn child. He gave up his full-time job and he applied for Social Security child and care benefits, but he was denied, just like those cases that Professor Graham mentioned. Widows could receive the benefits, but not widowers. And Stephen wrote a letter to his local newspaper in New Jersey, and he said he was sick and tired of women's liberation. He told the story of the discrimination he had just suffered, and he said someone should tell that to Gloria Steinem. His complaint was referred to the ACLU, and Justice Ginsburg and her students litigated the case, and they won a unanimous decision in the Supreme Court, which found that that Social Security policy was unconstitutional. And when she told the story here at Touro, she ended it by saying that Jason was 2 years old. The baby was 2 years old by the time the court rendered its decision. But at the time she was talking to us in the auditorium, he was a third-year student at Columbia Law School, and that she was about to officiate at his wedding. So I end with that story because I think it underscores her lasting legacy. We could go on and on about how all the people who knew her well, and a good friend of mine was a clerk of hers, and everyone talks about how she interacted in such a personal way with the people around her. And she, I don't know how many weddings she officiated at, but her lifelong project, both as a litigator and as a Supreme Court justice, was about breaking down gender stereotypes that are reflected in society, that are reflected in the law. And it was her advocacy that finally moved the court away from playing its role as benevolent protector of women, which she characterized as placing women in a cage, not up on a pedestal, to instead playing a role of enforcing norms of gender equality. Thanks, Rodger.
Thank you, Eileen. Our next speaker is Professor Laura Dooley. She's a professor of law at Touro Law School, and she teaches civil procedure and torts, among other subjects. And I'm hoping that perhaps we'll hear a little bit about Arkansas, but perhaps not. Professor Dooley, the floor is yours.
Thank you. I'm always happy to talk about Arkansas. And Marty Ginsburg was right. There is nothing else to do in Little Rock on a Friday night. This is so wonderful to be in this program with these amazing colleagues that you're getting to experience and that I get to experience on a regular basis. It's such a privilege. And I'd like to talk about how Justice Ginsburg's personality, which you've heard some about already, touched me personally, and then how she touched, I think, all of us profoundly with the work that's already been described in some respects, but I'm going to shift the focus a little bit, as is my wont, because I'm a proceduralist, to her work as a civil procedure scholar and litigant and justice. And then I'll circle back around to a later personal story. So the first personal story comes from a event that happened in Cambridge, England, and the year was 1994. And I think I may have some colleagues from Valparaiso out there in this webinar participating, so shout out to you all. We had a program in the summer in Cambridge, England, and Justice Ginsburg was a visiting scholar in that program, and she taught our students. It was incredible, along with my colleague Rosalie Levinson. And my daughter, this is 1994, was turning 6 during Justice Ginsburg's visit. So at the end of a lovely evening of dinner and conversation, a cake was brought out to honor my 6-year-old who was there, Sarah, and Marty Ginsburg, who was famously the more gregarious of the two of them, immediately burst into the happy birthday song, and Justice Ginsburg joined right in. And it was really cool that they were willing to just let the focus be on my 6-year-old for a few minutes there, these very esteemed people. So I thought that was really indicative of what's so special about Justice Ginsburg. And here's how it carries over into the profound way she affected all of us, I think, through her civil procedure scholarship and her jurisprudence around civil procedure. And this carries on a theme that you've already heard from both Eileen and Tiffany. Justice Ginsburg was always aware of the people behind the cases. And just this week, we studied in civil procedure a case called McIntyre versus Nicastro, which involved young man in New Jersey who was injured by a shearing machine, severely injured by a shearing machine that was manufactured in England and then imported into the United States, and that was bought by his employer and ended up in New Jersey injuring him. And he sues in his own home state of New Jersey, not surprisingly. And the case holds, there's no majority opinion, but there's a vote of 6-3 that there is no personal jurisdiction over the manufacture of the machine in New Jersey where the accident happened. And Justice Ginsburg writes a dissent in the case for herself and 2 others, so 3-person dissent. And she talks about the effect it has on this plaintiff, right? This plaintiff is now not able to sue in the place where the accident happened, which is his own home state. And she has this beautiful rhetoric in the case, in the dissent, about how this corporate manufacturer has essentially insulated themselves from jurisdiction in the place where their product injured a plaintiff by having this importer, this middleman, which couldn't be sued, by the way, because they had gone belly up, they were bankrupt. And the language that always stood out to me, so I put it on the slide, is that she says, so all a company has to do to avoid jurisdiction, avoid being held accountable in the place where their product causes injury, is to wash their hands pilot-like by employing this middleman, this importer. And it's really, I think, a vivid image of the effect of that might go a little more under the radar screen than the high profile cases in the con law arena, but really impact people, right? Everyday people who aren't able to get relief because of these esoteric doctrines like personal jurisdiction. And in fact, in my first day slides for both civil procedure and torts, I've gotten in the habit of including a slide where I encourage the students to choose a role model. Choose a role model for who you want to be as a lawyer. What can be accomplished as a lawyer? And 2 of the people on that slide are Justice Thurgood Marshall and Justice Ruth Bader Ginsburg. And who better to aspire to? And now to bring it back around, the little girl who turned 6 in 1994 is obviously all grown up now. And a couple of years, and she has a little sister who's also grown up. And a couple of years ago, we were getting together for Mother's Day in May. And it was when the documentary RBG was in the theaters. And we went, I kid you not, to 3 different theaters in Manhattan before we could get tickets because it was sold out everywhere. We finally did get tickets in that 3rd theater. It was pouring rain, by the way. We finally did get tickets in that 3rd theater, and we go in and the entire audience was full of what appeared to be mothers and daughters on Mother's Day taking in this documentary of RBG. And I just thought that was fitting. And I think Justice Ginsburg would be honored by that. So I'll leave it there, and thank you for the opportunity to talk.
Thank you, Professor Dooley. The bar keeps being raised. Our next speaker is Deseriee Kennedy. She's the Associate Dean for Diversity and Inclusion and also a professor of law at Touro Law Center. And Professor Kennedy teaches, among other things, civil procedure and family law. And Professor Kennedy.
Rodger, thank you so much, and thanks for this opportunity to speak about RBG. And what I want to start with is, while I respect and celebrate Ginsburg as a gender revolutionary, as we've heard, in the name of Breonna Taylor, Sandra Bland, and others, it's important to acknowledge that in America, racism is not a postscript, it is our legacy. Ginsburg knew this and spoke boldly about the scourge of racism. In fact, she earned the moniker, the notorious RBG, in part because of her dissent in the voting rights case, Shelby v. Holder. RBG's opinions often highlighted the biases that sustain structural and institutional racism. In her concurring opinion in Grutter versus Bollinger, which upheld Michigan Law School's admission policies designed to achieve diversity, she stated, "It is well documented that conscious and unconscious race bias remain alive in our land, impeding realization of our highest values and ideals." RBG disagreed with the position that we should treat all racial classifications similarly. In Gratz versus Bollinger, she dissented from the opinion which held the University of Michigan admission policies' use of race as a factor violated the Constitution. She wrote, "This insistence on consistency would be fitting were our nation free of the vestiges of rank discrimination long reinforced by law. But we are not far distant from an overtly discriminatory past, and the effects of centuries of law-sanctioned inequality remain painfully evident in our communities and schools." Ginsburg's dissent referenced the concrete vestiges of white supremacy, noting that in the wake of a system of racial caste only recently ended, large disparities endure. Unemployment, poverty, and access to health care vary disproportionately by race. Neighborhoods and schools remain racially divided. African Americans and Hispanics generally earn less than whites with equivalent levels of education. Equally credentialed job applicants receive different receptions depending on their race. Irrational prejudice is still encountered in real estate markets and consumer transactions. Bias, both conscious and unconscious, reflecting traditional and unexamined habits of thought, keeps up barriers that must come down if equal opportunity and non-discrimination are ever genuinely to become this country's law and practice. Quoting law professor Linda Hamilton Krieger, she wrote, "The stain of generations of racial oppression is still visible in our society, and determination to hasten its removal remains vital." Perhaps RBG's most famous comment on racial inequality is the one I alluded to earlier from Shelby County v. Holder. When the majority held that the Voting Rights Act preclearance formula was unconstitutional, Ginsburg vigorously dissented. Her dissent detailed the myriad ways cities and states continue to suppress the Black vote and disenfranchise people of color, including dual voter registration systems, redistricting, restricting early voting, and purging voter rolls in Black and Latino neighborhoods around the country. She famously stated, "Throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet." Her opinion lionized the struggle of African Americans for voting rights and the events of Bloody Sunday in Selma, urging a steadfast national commitment to the task, since in Martin Luther King Jr.'s words, "The arc of the moral universe is long, but it bends towards justice." RBG was a light in the fight for justice, but she was human. She didn't always appreciate contemporary issues of racial justice, such as the movement against police brutality. And in 2016, she called Colin Kaepernick's protests really dumb and his actions arrogant. Some have reasoned that her comments reflect the depth of unconscious bias, how far we have to go as a nation, and that even the notorious RBG is a product of our racialized climate. So it's a reminder for all of us to investigate our privilege, to be respectful of the experience of others, and to recall Martin Luther King's poignant missive, Letter from a Birmingham Jail, in which he responded to critics of the civil rights movement in Birmingham, Alabama, by retorting that protests were occurring in that place because of the injustice that existed there. He advises those disquieted by dissent to be concerned about the actions that brought about the demonstrations and not the demonstrations themselves, noting, oppressed people cannot remain oppressed forever. The yearning for freedom eventually manifests itself. As a postscript to the Kaepernick statement, Ginsburg apologized for her comments, illustrating the importance of having the courage to admit when you're wrong and when you may have more to learn. RBG wasn't perfect, but perfection is not the goal. She understood that with privilege comes the obligation to use your voice and to be immoderate when necessary. RBG's determined optimism, of which she often spoke, is a reminder to never give up on the promise of justice. May her memory be for a revolution. Thank you, Rodger.
Thank you, Professor Kennedy. Our last speaker for this part of the program is Professor Jeffrey Morris. He is a professor of law at Touro Law Center. He has written histories of courts and biographies of judges. He teaches constitutional law. Professor Morris.
Can you all hear me? Yes, good. Let me begin by saying that Dean Glickstein, in speaking about Justice Ginsburg's visit to the law school, was part of a program where the dean invited one judge each year to sit in residence and meet with students and teach classes. It was a very successful program, and perhaps its greatest success was with Justice Ginsburg. But I hope we can return to it soon. Ruth Bader Ginsburg made a remarkable contribution to American constitutionalism. She's joined in comparison with Thurgood Marshall. That comparison is somewhat deceptive. Marshall argued a great number of cases in the South, not just constitutional cases, but cases where he was defending African-American defendants accused of either rape or murder. And his life was often in danger. And he spent often many evenings sleeping in the homes of individuals because there were no hotels or motels that served African Americans. The difference between Marshall and Ginsburg is erased by the fact that each of them opened an area of civil liberties law which benefited deeply the nation. RBG was no truculent feminist. She was gracious and warm, and on both courts that she sat, the DC Circuit and the Supreme Court, or perhaps uniquely on the DC Circuit, she was able to get along with everyone. Some found Justice Ginsburg cold and uninteresting in people. Those who knew her saw something rather different and it's extraordinarily paradoxical. Justice Ginsburg was a profoundly shy woman who spoke with long pauses between sentences and often without profound affect in her voice. As an individual, she was warm, she was gracious, and she was thoughtful. My own experience with her was extremely pleasant. I began and finished ultimately a book on the Court of Appeals and the district courts in the District of Columbia. And she supervised that book until, and I had very mixed feelings about it, until she was promoted to the Supreme Court. And when I knew that if on the one hand, this was a wonderful thing for the Supreme Court, it was a terrible thing for my book, not to be dealing with someone wise, bright, diplomatic. She hid in public this extraordinary warmth. And I just want to give you one example that obviously would mean more to me than anyone else, but I think you can understand what it meant. On June 25th, 1996, the court decided United States versus Virginia, the VMI case that Professor Kaufman has been talking about. The next day, the day after that the great decision came down, this letter came with a copy of the decision to me at the law school. Quite simply this: Dear Jeffrey, for the concluding thought, I turn to your father. See page 41, footnote 21. And it happened in his statement in a book about by my father, who was a distinguished historian, whom I think never knew Ruth Bader Ginsburg. But she had the kind of warmth to know, even at a time when she must have been receiving plaudits as well as condemnations all over the country, to find just this little bit of time to do something very nice. That's what I have for today.
Thank you, Professor Morris. There's one or two questions in the Q&A, and I'll go to those in a moment. I invite anyone attending, if you have a question, we have some time. Please feel free to ask it in the Q&A section on the computer. And here's the question. One of our alums writes, Justice Ginsburg is known for her dissents and how powerful they can be, as Professor Kaufman noted in discussing the Ledbetter case. And the question for each panelist is, do you have a favorite Justice Ginsburg dissent? And if not a favorite dissent per se, then perhaps one that has had a meaningful impact on our nation's laws and cultures. And so I would open it up to the extent that we haven't discussed this already to respond to the question. And I see that Professor Kaufman raised her hand. So I'm going to mute so that you can answer.
Thanks, Erica, for that question. I would say Justice Ginsburg's dissent in a case called Gonzalez against Carhart. It was a case that challenged a ban on a particular medical procedure, a particular type of abortion used in late-term abortions. And despite what the court said, the medical community felt that it was medically necessary in some cases. But this law banned that procedure. And it was upheld in a 5-4 decision. And the reason I remember Justice Ginsburg's dissent so well is she was furious at the majority's notion that one of the reasons they gave for upholding that ban was that women need to be protected from themselves against making bad judgments. And the majority said, well, women may over the years come to regret that decision. And she really blasted the majority for being so paternalistic, and she accused them of returning to a way of thinking that permeated the Supreme Court's equal protection jurisprudence for a full 100 years after the Equal Protection Clause was ratified. I mentioned the court playing the role of benevolent protector before. Well, she blasted the majority for returning to that long discredited philosophy of failing to give women or believe and trust women to make their own autonomous decisions. So that's the dissent I most remember.
Would anyone else like to speak and answer that question? Deseriee, is that
a lot of my talk came from her dissents, and I think she took very powerful positions against discrimination in a very eloquent way. And one of the things I really enjoy about her opinions, and in particular her dissents, about not only how thoughtful they are, but how incredibly well researched and resourced her opinions are. And the quotes that I read from her opinions, not only are they nearly poetic, but they're all incredibly footnoted, right? That she is a student of history. She read law review articles. She had a vast understanding of a great number of issues, and she incorporated all of that, international conventions, into her opinions. And I think it's really a lesson for all of us about the importance of not only being measured and aware, but also to be prepared and to just know your stuff. And I mean, I don't think you can beat her umbrella comment. I mean, I just think she just hit the nail on the head, is how do you remove some protections on the basis that you're being protected, and therefore you no longer need them. So she is or was really remarkable. So
Professor Graham had to leave because she teaches in about 5 minutes, and so that's of course a higher priority. She mentioned that the Shelby County dissent also sort of is at the top of her list. Does anyone else want to speak? Professor Dooley.
And I agree that umbrella comment is perfect. But I'll take it back to procedure and just mention, I think this goes to Professor Kennedy's point about careful thought and research. I'm thinking of a case where it's an Erie doctrine case, right? So, and the court has to decide about the balance between state power and federal power, and the balance between decision makers, juries and judges. And she does a very careful opinion about, yeah, we can respect the substantive law of the state of New York when we're reviewing jury verdicts, but it needs to be done in a way that doesn't interfere with the Seventh Amendment protections against reexamination of verdicts. And it's, some might say she split the baby in that opinion. We proceduralists could probably debate that, but it's, if nothing else, an example of what we've all been talking about, the very careful thought and research that went into a Ruth Bader Ginsburg opinion, whether it was a majority, as that one was, versus a dissent.
Thank you. Professor Morris, please.
Yeah, Rodger, this comment isn't specific to the question that was asked, but it seems to me it's close enough, which is if one would look ahead or try to look ahead 25 years and say, what was Ruth Bader Ginsburg's most important legacy or legacies? I think it will not be her Supreme Court career, even though it was long and it was distinguished. But there are very, very few majority opinions of enormous significance. And even in dissents, she often deferred to Justice Souter, Justice Breyer, Justice Sotomayor. Why? Why is really very simple. One, she was hardly, or at least her wing of the court was hardly in the majority of the 27 years she was on the court. When it was, she remained for an enormous amount of time the junior justice and was not assigned opinions of enormous consequence. So I think when all is said and done, the greatness of the legacy is going to come in gender equality. One, as the substance, but two, the strategies she used in her gender discrimination case. That's what I think will be relatively immortal, and not the court career, apart from U.S. versus Virginia.
Thank you. Howard, do you have anything to say? I have my own sort of esoteric favorites, but if anything you'd like to add, Howard?
Not about her opinion, but she was always very proud of the work of her husband. She said that the most popular book at the Supreme Court bookstore was a book called The Supreme Chef, which was a book of recipes by her husband, who did all the cooking at home. I think she said since they married, she never did more than make a cup of coffee, and that wasn't her field of expertise or interest.
In that sense, it's actually quite responsive to the question, because the question did ask about dissents, and we would see, of course, her husband as the author of the majority view of the cookbook, whereas as, merely the person who benefited or ate those meals, not in the majority. So Jeffrey touched on something that I think is in some ways related to the observation about one of the things that really intrigued me about Justice Ginsburg. And again, I recognize that her work in constitutional law, is paramount. But because I teach civil procedure, the thing that really intrigued me was, and you wouldn't necessarily expect this, especially when you look at the vote count in some of the decisions, she had great respect for the integrity of how state court systems operated. And so in Jeffrey's comment, there was, I think, comments where there were notions of, there was an explanation as to, at least on the Supreme Court, how she ended up deferring to others. Now, in the cases that I'm thinking about the most, and there's a series of decisions in punitive damages cases where through, I think, starting in the 90s through the 2000s, she dissents in a number of cases in which the Supreme Court has taken on for itself the task of reviewing punitive damages awards in a substantive way. That is to say that at some point they could be excessive or should be reduced in some way. And consistently, she said, that's not our job. If the case was properly tried, if it was properly litigated up through the state court system, our work here is done. And someone who I felt had a similar, extraordinary ability as both a writer, as both a researcher, that is, in the clarity of the writing, in the depth of the research, was Justice John Paul Stevens, who voted with her often. And yet in this area, they parted ways. And I think by the end of those cases, I think Stevens may have reconsidered and said that in the end, perhaps we should have just left this alone, which was her position. And that's always struck me as just a very sort of interesting slice of her work. It's 1:33 now. The program is scheduled to continue. That is, we are scheduled to go to 1:45, but I just want to let students know, if you have a 1:30 class and you're still here, you're late.
Rodger, I believe you're muted.
I thank you for letting me know. I can tell you safely that that was not my most brilliant insight of the day, so nothing was missed. Jeffrey, can you say a little bit more about her tenure on the DC Circuit? And you, Jeffrey, now you're muted.
Yes, I can, at least a little more. She was a moderate justice, sort of in the middle of a court that usually had nobody in the middle. It was a moderately, somewhere between a moderate and a moderate conservatism. She was, in her DC Circuit days, pretty tough on criminals. And she often joined with the conservatives on the court in those cases. On the other hand, she really was, with perhaps Judge McGowan an exception, one of the few human beings in the last 75 years who could get along with the majority of the DC Circuit. She was her own person. She was moderate. Even in the Supreme Court, I'd say, although she was a strong believer in the 4th, 5th, and 6th Amendments. In the last few years, the justice who has represented that most strongly really was Justice Sotomayor. Does that add a little?
Yes, it does. And on that court, even though your description of it, I think, is fairly, if you will, moderate or centrist, who were on each side, if you will, the sort of most, if you want to use liberal and conservative, who were on the ends there? Who was on the ends there? Oh, you're muted again.
Jeffrey, you're muted.
Sorry. Beginning in the 80s, the truly most conservative members of the court were Justice Scalia, Justice Bork, and someone else. Oh, and slightly more moderate Kenneth Starr. That was the one side. The other side was largely made up in the early 80s of the aging lions of that court, of David Bazelon, of Skelly Wright, of Spotswood Robinson, who was one of those who argued Brown versus Board of Education. Those were, I think, the extremes at that time.
Thank you. One last question, and this is really, we've adverted to how she was known, right? The notorious RBG. I'm just curious as to, we've all taught Justice Ginsburg's decisions or dissents. What is it that you think, it's really the most unlikely path to celebrity, if you will, to have this sort of broad appeal that she became so well known. And Laura, your story reminded me of that, about sold out. What do you think that was all about? And I'm just curious to see what anyone said.
Well, sorry, go ahead.
In New York, she continued to be very popular. I was once in a theater in Manhattan where just before the performance began, she and her husband entered to take their seats, and people in the audience noticed it, and immediately she got a standing ovation from everybody in the audience. I guess she was also notorious because occasionally she was maybe inappropriately outspoken. During the last presidential campaign, she publicly criticized Trump and called him a faker. And she later apologized for doing that, which was an inappropriate comment for a justice of the Supreme Court. And perhaps that contributed to her reputation as being notorious, because she was willing to be so frank.
Laura?
Yeah, I was going to say, obviously it was a play on Notorious B.I.G. And in the documentary, there's a moment when they talk about that. She talks about that with her granddaughter. And I like to think, I have no evidence of this other than my own speculation, that she became a rock star because of her quietness, because of her steadiness. And she wasn't perfect, as has been pointed out, that's for sure. And but she was big, small of stature, but big of soul and heart, in her willingness to acknowledge her mistakes about Colin Kaepernick, about perhaps being more outspoken than we expect judges to be in terms of during a political campaign. And so I like to think that it's an admiration that we still share as Americans in this very fraught moment for folks who are bigger than the moment, who can both do great things and remain humble, and have the courage to acknowledge that there's still work to be done.
Rodger, could I add something?
Please, Eileen. Yeah.
I just want to say something about her collars, because I think that's a part of the answer. So, yeah, the New York Times had a great story about the collars a couple of days after she died, and it told us that when she joined the court, she sat down with Sandra Day O'Connor and said, these robes are meant to be worn by men, because the way they're cut is designed to show the collar of a man's dress shirt and tie. And really, you know, we don't want to pretend to be men. So she started, you know, the tradition that became, you know, it's on the backdrop behind us of wearing her collars. And she had quite a collection. And this Times article reminded us that she wore different collars when she was in the majority than when she was in the dissent. And her dissenting collar was a spiky bejeweled necklace on a black band. So that's, you know, that makes sense when you think of her as a notorious RBG. And she wore that dissent collar the day after the 2016 election.
Anyone else want to? We're near the end. Concluding thoughts by anyone? Any final thoughts? So, thank you, all of you, for participating in the panel. Thank you, audience, for those of you who were here to listen in on the program and for your questions. The last thing I'll say is that the Toro Law Review in the spring will be doing tributes or paying tribute to Justice Ginsburg in that issue. And so we'll be saying more about her then in the Law Review. Thank you again. That's the program.